right, staying with the Supreme Court, in an official opinion released today, the justices ruled in favor of the Biden administration in a case involving social media. The arguments pitted the White House against several Republican-led states. At issue was how far the federal government can go to combat controversial social media posts. The 6-3 vote threw out lower court rulings that favored Louisiana, Missouri, and other parties. They claimed the White House leaned on social media platforms to silence conservative points of view. And for analysis, we turn now to Charles Chip Miller, senior attorney at the Institute for Free Speech. His group wrote an amicus brief in favor of the plaintiffs in this case. Chip, good to be with you. First, your reaction to the Supreme Court ruling.
Hi, Tracy. First, at the Institute of Free Speech, we are disappointed in this ruling. This goes a long way to allowing the government to coordinate with social media companies to take down speech that disfavors.
Yeah, and for those who may not have been following this case, can you tell us a little bit more about it and what were the big concerns or issues for the plaintiffs?
Yeah, so this started back in COVID, and as you recall, the Biden administration was particularly active at interacting with social media companies and asking them to take down posts that they disagreed with regarding the source of COVID, whether it originated in China and whether it started in a lab, and also particularly about the effectiveness of vaccines and any health effects about that. So these plaintiffs sued because either their speech had been removed for the individual plaintiffs, and for the state plaintiffs, they wanted to represent the right of their citizens to be able to engage with the views that are out there, what is known as simply the right to listen. So they want to be able to hear information that's out there on these topics.
Yeah, and what does this mean for government agencies and their dealings with social media platforms?
Yeah, so what the court decided, the majority of the court, it was a 6-3 decision with 3 conservatives dissenting, which is different than what you often hear. But the 6-3 majority here made a procedural ruling, somewhat like in the last case that you were discussing that maybe will be released tomorrow. And the procedural ruling here was that the plaintiffs did not have standing to bring the case, meaning that the court would not hear their substantive claims. And it spent a lot of time and effort distinguishing these individuals from the claims that they sought to bring. We think that they broke new ground here in the sense that usually a plaintiff is allowed to bring a First Amendment free speech claim if they think that their speech is being chilled. Here, in the decision written by Justice Amy Coney Barrett, they said that that is not the case.
Yeah, and Chip, when it comes to flagging misinformation or disinformation, how might that impact groups, say, like religious organizations or even the Catholic Church, especially when it comes to topics like abortion?
Yeah, so what this case essentially means is that you have to dot all your I's and cross all your T's and know exactly what person within the government contacted which person at the social media companies and demanded something to be taken down. This is a case where, as indicated by Justice Alito in his dissent, that was joined by Justices Thomas and Gorsuch, that the court here really is, and frankly, missing the forest through the trees. Whenever you have actions that are taken on behalf of a government to covertly go and ask a social media company to take something down, there's not going to be good records of that. So it really, really makes it difficult to prove this out, which is why when we filed a brief in this case, what we argued is that the rule should be that the government should never be allowed to request the takedown of political speech. It's one thing for the government to get out there and say that, to give counter speech of its own, say we disagree with the opposing side here. But anytime the government is just out there and secretly asking for speech to be taken down, that should be found to be a First Amendment violation straight out, and it shouldn't matter what impact that has on the decisions of the platforms.
Well, Chip, great to be with you. Thank you so much for coming on today. We appreciate it.
Absolutely. Thank you.